cordially thank the organizing committee and the steering committee for their kind invitation, which gave me an excellent opportunity to deal with a topic that is so central to my own research interests. My vantage point is at the crossroads of pragmatics, with special emphasis on social deixis and reference, critical discourse analysis, with work on ideology and power negotiation, media studies, with special focus on framing, rhetoric, with special focus on antonomasia, and cultural studies, with special focus on minority groups. I was planning to talk about the Palestinian refugees as a case study, but I realized a bit late that I had already delivered 2 papers on this issue, and I needed to say something new. But I've already talked about the Palestinian case in Sousse here 2 years ago, and in Beja. And I'm writing a book on that. All right, background to the study. A quick survey of the literature reveals the dearth of research on refugee studies, despite its importance, especially in the Middle East region. Yet the importance of the issue cannot be denied. At the political level, the strong policy orientation of much of the work in the field has been shaped the way refugee issues are framed by scholars as well as practitioners. There are also vital legal consequences of the act of labeling. To this are added important implications for media effects. Research has shown the interdisciplinarity of refugee studies. For FABOS 2015, the study of refugees is not a discipline, but rather a multidisciplinary or interdisciplinary approach to the refugee as a specific type of migrant. This is corroborated by Burmesh 2017, for whom the terms immigration, otherness, citizenship, multiculturalism, and Britishness are considered among the major concerns of cultural studies. Research has also shown a lack of consensus as to what the focus of study is or should be. As has been perceived by this author, several refugee studies programs have recently changed their focus of inquiry from refugees to forced migrants or even migrants. The development not only reflects an increasing academic interest in a migration-asylum nexus, but also a political departure from providing protection by states. While researchers have long argued that the line between seeking asylum and seeking a better life is very blurred, the shift in emphasis away from refugee studies to migration studies follows the move on the part of government agencies, policy institutes, and other funding bodies which seek to commission research along these new lines. In the Arab world, Palestinian refugees in particular face a terminal situation of legal limbo. The ultimate goal of Palestinian statehood remains a distant hope, while Arab governments keep them at arm's length. The bone of contention is the label refugee itself, which commonly refers to someone who is forced to migrate rather than someone who has moved more or less voluntarily, and who is a person with particular experiences and needs for whom special measures of public policy are justified. In the second half of the 20th century, the refugee label was increasingly tied to legal status, defined by states through international legal instruments such as the 1951 Convention on the Status of Refugees, and granted to those who could demonstrate that they fled persecution in one state across an international border to seek protection from another. From a historical perspective, FABOS 2015 considers both refugees and refugee studies as being products of a nation-state system historically linked to Western political philosophy. International legal frameworks for the protection of refugees have developed primarily due to European experiences in the 2 world wars, where millions of Europeans were displaced in the continent-wide conflicts. In the same vein, RACOMA 2018 avers that the degree of control over their borders varies by state. For example, the Schengen Agreement was signed in 1985 by states in Europe. The agreement made it possible for citizens or states that signed the agreement to freely cross their borders. In 1999, the Immigration and Asylum Law of the European Union was finalized. This allowed nationals from the European Economic Area the right to live, reside, and work in any of the states that are members of the European Union, including the right to access social services. As for the United States, it has a different method for the selection of legal immigrants. Three components are included in the legal immigration to the US, namely family, employment, and humanitarian reasons. Another angle from which this problem has been seen is that of the effects of migration. According to RACOMA 2018, immigration is closely related not only to citizenship, but to the political and social rights that are bestowed upon them as well. A further angle of vision is the legal dimension. As has been pointed out by Inhavitan, the refugee is a figure at the core of the international refugee regime, its point of reference for actions and reasoning. Consequently, the regime offers codified definitions of the term refugee. For this author, the legal concepts that are institutionalized on a global macro level have consequences on the lower levels of an institutional regime. The codified definitions of the refugee in international and national law have considerable impact on opportunities, actions, and interpretations within the international refugee regime for states, organizations, and the people classified as refugees or excluded from the status by these definitions. To this effect, Coutin, 1998, contends that the power of immigration law is often assessed by the law's ability to control the border. Because illegal immigration is not eliminated by criminalizing unauthorized entry, law appears weak. In contrast, shifting the focus from the law's ability to control entry to immigrants' attempts to negotiate their legal status in the United States suggests that, far from being powerless, law is critical to both immigrants and authorities' political maneuverings. Conversely, Coutin contends that the focus on immigrants and activist legislation and strategies details one of the ways that immigrants attempt to shape their own identities and futures. Since the development of dependency theory during the 1970s, migrants have often been depicted as pawns of global economic and political forces, buffeted about by state repression and capitalist penetration. Examining immigrants and activist legalization strategies reveals that immigrants play a part in shaping the policies that affect their lives. In tandem with this legal perspective, the refugee problem has been depicted from the lens of the United Nations High Commissioner for Refugees. The United Nations report spells out the legal status of refugees in international law. Refugees are defined as people outside their country of origin because of feared persecution, conflict, violence, or other circumstances that have seriously disturbed public order, and who, as a result, require international protection. Their situation is often so perilous and intolerable that they cross national borders to seek safety in nearby countries, and thus become internationally recognized as refugees with access to assistance from states and relevant organizations. They are so recognized precisely because it is too dangerous for them to return home, and they therefore need sanctuary elsewhere. These are people for whom denial of asylum has potentially deadly consequences. The legal texts relevant for this angle are Article 14 of the Universal Declaration of Human Rights, which asserts the right of everyone to seek and enjoy asylum. However, no clear content was given to the notion of asylum at the international level until the 1951 Convention related to the status of refugees was adopted. And the United Nations was tasked to supervise its implementation. The 1951 Convention and its 1967 Protocol as well as regional legal instruments such as the 1969 our Convention governing the specific aspects of refugee problems in Africa, are the cornerstone of the modern refugee protection regime. They set forth a universal refugee definition and incorporate the basic rights and obligations of refugees. The provisions of the 1951 Convention remain the primary international standard against which any measures for the protection and treatment of refugees are judged. Its most important provision, the principle of non-refoulement, meaning no forced returns, contained in Article 33, is the bedrock of the regime. For the High Commissioner, the real need is to find more effective ways to implement it in a spirit of international cooperation and responsibility sharing. At a time when some policymakers, international organizations, and media outlets understand and use the word migrant as an umbrella term to cover both migrants and refugees, the United Nations report warns against blurring the terms refugees and migrants, since that might take attention away from the specific legal protections refugees require, such as protection from refoulement and from being penalized for crossing borders without authorization in order to seek safety. The report does not find anything illegal about seeking asylum. On the contrary, it's a universal human right. It concludes that conflating refugees and migrants can undermine public support for refugees and the institution of asylum at a time when more refugees need much protection than ever before. The United Nations report enumerates the factors leading people to move, which can be complex, to conclude that the causes are often multifaceted, as migrants may move to improve their lives by finding work or in some cases for education, family reunion, or other reasons. They may also move to alleviate significant hardships that arise from natural disasters, famine, or extreme poverty. People who leave their countries for these reasons would not usually be considered refugees under international law. And there is a big section on forced migration, which I have to skip for time reasons. I move to the statement of the problem. It transpires from the above survey that the most important angle remains that of labeling the social categories of people involved in this process, and the socio-economic, political, and legal consequences of this framing device. So I move to some technical terms that have been used in the literature. The distinction between emigration and immigration. For Racoma 2018, although these two terms apparently have the same meaning, the difference lies in the application. This author maintains that emigrate means to leave a person's region or country to settle into a foreign location. It also means a permanent move, like immigrate. The Latin term emigrare, or to move in English, is the origin of the term emigrate. The main difference between immigrate and emigrate is in the direction of the action. Immigrating means entering another country and making it the person's permanent residence, whilst emigrating means leaving a country to permanently settle in a foreign country. Fabos outlines the terminological confusion ensuing from the use of analogous yet subtly different terms. For instance, those individuals determined by states as unable to demonstrate persecution to the satisfaction of states have been assigned various other bureaucratic labels, including asylum seekers, economic migrant, failed asylum seeker, illegal migrant, among others. The term forced migrant has also come to describe, in addition to refugees, all those people displaced by violence or injustice in their areas of origin, who nevertheless were not seen by states to be deserving of internationally sanctioned protection. These include internally displaced persons, those who have been uprooted by development projects, the ousties, and those who have been forcibly relocated to new areas by their own government, forced resettlers. According to the special glossary of legal terms, the following terms must be distinguished. Refugee, a person who is forced to flee from persecution. Asylum seeker is a person who is seeking asylum. Until a determination is made, it is impossible to say whether the asylum seeker is a refugee or not. Political refugee and economic refugee, internally displaced person, stateless person, immigrant, migrant, economic migrant, person without status or undocumented, illegal migrant, illegal immigrant, alien, and so on. Amundsen et al. 2014 provide a number of examples showing this terminological confusion. For instance, the term illegal alien is the official or technical label used in immigration law to describe a foreigner who enters the US without an entry or immigrant visa. For example, a person who crosses the border by avoiding inspection or who just overstays the period of time allowed. However, this author does not find any common agreement in the public discourse about what label to apply to unauthorized foreign nationals residing in the US. This author notes that the media in the US often refer to unauthorized foreigners by using different labels interchangeably. The labels commonly used include illegal immigrants, undocumented immigrants, and illegal aliens. These authors argue that these terms are formally equivalent according to US immigration law, since they all refer to the same category of unauthorized foreign nationals residing in the country. Nevertheless, there seems to be a struggle over framing or a struggle over words in trying to identify the most accurate label when referring to unauthorized immigrants in public communication. It transpires from these terms that refugees and migrants seem to attract water imagery. We hear of refugee flows, floods of immigrants, pools of refugees. The next section discusses the impact these images have on our attitudes of the people under discussion through the process of framing. And here I come to the core of the paper, where I deal with the underlying mechanism, the système sous-jacent, where I deal with media framing through labeling.
2 minutes again, sir.
How many?
2 minutes.
2 minutes.
Yeah.
This is where the paper starts. Oh my God. Amundsen et al. Stipulate the existence of a relationship between the labels used and subsequent attitudes. To account for this causal link, these authors invoke the concept of framing. Following Pearson, they cite the fact of labeling unauthorized Mexicans in the US as illegal aliens. To prove the importance of labels in social media framing, Lee and Nervius, 2018, maintain that the use of labels has the potential to shape the range of possibilities for understanding what the story is and the way migrants and refugees are perceived. Negatively labeling and framing refugees and migrants may lead to serious problems in the host societies, where perceptions are significantly influenced. Lee and Nervius argue that the labels and frames provide indications of the ways in which displaced people are received and perceived across Europe and beyond. Labeling has been seen as a framing strategy. To this effect, Lee and Nervius argue that frames elicit as well as constrain the interpretive activities of audiences. And here they rely on the work of Entman, 1993. These authors consider labels as the building blocks in the creation of frames and further postulate that the selection and use of labels is a crucial and important instrument in the process of framing particular events and individuals. So they talk about the labeling battle, the history labeling as a battle. They talk about labeling as a social construction of reality. Okay, I have to move. So the bone of contention is that terminology reflects differences of perspective or vantage point. Okay, and then I move to talk about other considerations that further complicate the issue. I talk about social inclusion versus exclusion, internal versus external exclusion, conflict of interests, and then I move to the way out or the future directions, how to solve the problem, empowering refugees, the need to simplify the legal jargon on immigration, revisiting the geopolitical dimension, the politics of vulnerability, utilizing the refugee label, how is global social exclusion to be combated, and then fine-tuning the concept of illegal immigration. Combating unjust laws is a moral obligation. Okay, I'll have to wrap up, I'm afraid. My main contention or my main claim is that no act of reference to entities is innocent. Every reference to entities necessarily, first of all, is loaded with value judgments, and it has a framing effect, and this framing effect is always purposive or goal-oriented. It always seeks to achieve a certain effect. Thank you.